Hey yo, what's going on? Not guilty boys, checking back in. It's attorney Michael Campbell along with my illustrious colleague, Mr. Andrew Wilkerson. How you doing, bro?
Oh, it's all good, man. Just happy to be back after a 9-day trial, just getting back in stride.
Yeah, man. So one of the things we want y'all to know, one of the main reasons we came up with the name, the Not Guilty Boys, is because we're actually criminal defense trial lawyers. That means that we have experience and multiple trials over the years of fighting justice for our client and for justice for our client. The Not Guilty Boys, the name itself derived from us hearing that two word verdict a lot at the end of trials. And it's kind of stuck with us since we have started our Wilkerson and Campbell law firm. I think the Not Guilty Boys fits well for me and Andrew because of the way that we prepare and plan and strategize for trial. Our whole reasoning of coming up with this name is because that's the two-word verdict that we want to hear the most whenever we take a case to trial.
Yeah, man, not guilty boys for me. It's straight to the result we get, baby. You know what I'm saying? That 2-word verdict. Everybody stand up, chin up, chest out, straight face. You know what I'm saying? Look the jury in the eye, look the foreman in the eye as they read off the verdict. That's what I'm here for, man. That's what I live for, man. That's what I do, just effortlessly, man. And I ain't bragging about it, man. I'm bragging in the Lord, as the Apostle Paul say. This is what I'm here to do, and I take pride in doing it. I'm just running my race, baby. That's
Drew,
it.
I know you did some mock trial work in law school that kind of helped you become a real good a great trial attorney. Can you tell you how mock trial in law school can assist a potential law student if they interested in going to trial one day?
Yeah, man. There's very, just like school period, there's very few things that give you a handle on the practical aspect of the profession while you're in school.
Absolutely.
Mock trial is one of those things. You got to understand, anybody that's been to law school is in law school now, or, plans to go to law school. I just want to tell you, you got classes, you got electives. You learning how to, first year of law school is they teaching you how to think like a lawyer, right? Just to think like a lawyer. Second year, they probably pile on the workload and you using your experience and know how to think like a lawyer. Third year, you just trying to get up out of there. You got a heavy workload, but you know how to manage your time. Ooh. But basically, trial man gives you the opportunity to stand on your feet and actually partake in a practice that, is very important, being an attorney, and that's going to trial, that's speaking to the jury, that's preparing for trial. They give you a packet. You know what I'm saying? They got different teams. It's very competitive. Different schools go against different schools. I know we went up against Georgia Tech, went up against Texas Wesleyan, went up against some well-renowned schools, man. And, my preparation just got to the point where it's almost like, anybody that plays sports, you know how you prepare for a game. You study your opponent and you heighten your skill set. You know what I'm saying? And it got to the point where in these, I ended up getting best oral advocate of the region, a couple times. I had some really good coaches. One, my favorite of all time, Leticia Quinones, very, very skilled attorney. Yeah, shout out to Leticia. Very skilled attorney, man, very direct, very blunt, but very charismatic at the same time. Just got the whole bag, you know what I'm saying? And I was blessed to be able to be taught by her. But basically, at the end of the day, the preparation that you learn in mock trial, it translates very easily. It just translates to the real world. They told me in mock trial, when you're done with this program, you'll be better than 80% of the attorneys out there that you go against. They told us that. I think they underplayed that. Some prosecutors learn trial skill by just doing trials, but by then it's too late. I'm already kicking your ass by then. You know what I'm saying? So like you falling and bumping your head and getting back up, and I'm just using the skills I learned 11 years ago. You know what I'm saying? Yeah, but anybody that I'm kind of different, man. Like while other people was trying to figure out what they wanted to do, I always knew I wanted to be a trial attorney. I just always knew that. So I was searching for different ways to kind of perfect those skills. But if that's something you want to do, that's probably something you should thrust yourself into. No matter if you feel you already got a lot of work in school to do, no matter if you feel you might not have time to do it, just get up in there, man, and you'll be thankful. You'll be thankful. Trust me.
Yeah, I didn't do my trial, but I was always interested. I did some more mock attorney situations like client consultations and
Negotiations. Yep.
Yeah, I didn't go.
Yep.
Well, why they ain't mentioned is that it's fun. It's really fun
Yeah.
as well as work. But you like you said, you learn that practical aspect of being a lawyer, which you just don't get that too much in law school. If I was to have my own law school, that'll be something I would make an elective. Like you got to take this class and you
Sure.
got to get some mock trial experience, regardless if you want to be a trial attorney or not. It's a good skill to have to be able to get on your feet, be prepared, and debate while your client has a winning position. So yeah, I mean, moving along, we just got out of a 9-day trial ourselves in Dallas County. It was an intoxication manslaughter trial. I mean, we're 14-0 in murder cases because ultimately we know exactly what we need to do to get ready for a trial. I mean, proper preparation is key to be to doing any trial, to being able to have that be a step ahead when it comes to going against the prosecutors. And I say this when it comes to trial. I don't think most prosecutors they have too much of a caseload to give the type
Mhm.
of most cases need. So I think they may wait until maybe the week before, a couple of weeks before to really put that preparation in. But
Big mistake.
when we planning and strategizing and preparing 3 to 4 months, sometimes 6 months ahead of trial, they are behind the 8 ball when it comes to that. So yeah, intoxication manslaughter trial out of Dallas, 9-day trial started. You guys may have heard about this case. I'm not going to say my client's name out of respect to her. But this is her first I ever been in trouble. Happened in February of 2020 in Dallas County in Uptown Dallas. It was a Sunday. It was Sunday Fun Day. And everybody know Sunday Fun Day in Dallas is a thing. In Uptown, it be popping. You know, you had Clutch right there. Back then you had Club Level right there. So it was a heavy traffic area. And if anybody know that intersection on Cedar Springs and Root, that's a bad intersection. It's just the makeup of the intersection. There's a lot of traffic accidents that happen at the intersection. And I just think it's a horribly designed intersection because you can go, most intersections you could go maybe 4 ways. This intersection you could go 6 ways. So it's not a well designed intersection. But on that day, my client is out celebrating her birthdays, Sunday Fun Day. And, you know, this situation can happen to anybody. She leaves Sunday Fun Day, you know, maybe had a drink or two, you know, like we all do. Leaves Sunday Fun Day. She's in her slingshot. She's going up Cedar Springs on her way home to get ready for work. And as she's going up Cedar Springs and coming up on off the route, however you say intersection, there's cars that's stopping. And in particular, there's a truck she's in the far right lane going southbound. There's a truck in the lane next to her that stops mid intersection. Okay. And that truck stopped because it saw the pedestrian walking across the street, even though the crosswalk sign had turned to do not walk. The lady was still walking across the street. As she came from behind this big Dodge Ram, my client hit her and she didn't see her. And she kept going, but she didn't see her. Okay. And that was proven at trial. But they stopped her down the street. She had some alcohol in her system, of course. So they did an SFST and they arrested her for what they told her DWI. They didn't even tell her about the wreck that fatality accident that she didn't know about that happened a few blocks back. They just told her we'll arrest you for DWI. Right away, she did the right thing because she called Wilkerson and Campbell from the jail. And I think, you know, that tremendously helped her in her case with getting her attorneys on board right away because now we had all that time. Like I said, this happened in 2020. We didn't go to trial until last week. So that's 5 years. We had 5 years on a case, going through evidence, preparing, strategizing, kicking things around that by the time we came to trial, we was ready to go. So that's one thing I want to impress on all of you listeners out there. If you or a loved one ever catch a case, it's better for you to get that attorney on that case right away. Some people like to sit around and let me see what the court-appointed attorney can do. I heard that before. That's not any good for you or your case. Because if you know you need a retained bulldog, such as myself and YD, to come in there and represent you, it's best to get us on that case right away for several reasons. Number one, you don't want that court appointed attorney doing anything that we wouldn't do. Number two, it puts us at a disadvantage hiring us in the 12th hour before you go to trial, because now we don't have as much time to prepare, like I said before. And number three, it's just not a good idea to have somebody, you're not helping yourself on an attorney in the 12th hour of a case. I always tell my clients that if you want to get an attorney, it's best to get the attorney right away. What you think about that, YD?
Yeah. Give Wilkerson and Campbell a call, man, or give somebody that you are comfortable with and confident in a call. Sitting around waiting to see what the court appointed gonna do. And I'm just saying that because that's what y'all say. Ain't really in your best interest, man. Like, you gotta understand, when you first go to trial, when you first get arrested, y'all in layup lines, you know what I'm saying? Dunking the ball, crowd yelling, you're comfortable, you're stretching. It's early. But if you hire me in the fourth quarter with 5 minutes left, you see what I'm saying? Like, you done put us at a disadvantage. You done put you at a disadvantage. We can't give you a payment plan like we usually would because you're already set for trial. You see what I'm saying? Our back gonna be to the wall, but that's cool. You know what I'm saying? We can handle that. But the smartest thing for you to do would be to give us a requisite amount of time, a good amount of time to prepare, to strategize. For instance, why let your court-appointed lawyer do the pretrial and then hire us for trial? Nah, I want to do pretrial. I want to set up this evidence to come in and not come in the way I want it to. I want to get this motion granted and keep this evidence out that the state trying to bring in the way that I want to on my own terms. You see what I'm saying? I don't want to have to pick up and clean up what another attorney did, only for you to pay me half my money and still expect, full effort, which you're going to get from me because that's just what I'm going to do. But, we've talked about that on previous episodes. That's why you charge people. A person will literally hire you with 2 weeks until they go to trial and want you to go through the evidence 77 times and come up with 3 different trial strategies, when they could have hired you 2 years ago. It just ain't smart, man. You just gotta, you just gotta do right by yourself, man. You just gotta do right by yourself. It's really about how much you value life, how much you value freedom. And that seemed like a deep thing to say. It seemed like a tall thing to say, but to be quite honest, I mean, that's, the more you value it, the more meticulous you'll be about it. Because we're meticulous attorneys. We want to check every box. We want to dot every I and cross every T, but you got to give us time to do it.
Absolutely. I mean, one of the main things we could do in the very beginning of your felony case is we could put together a grand jury packet. I have had numerous of cases. I mean, more than, 50 cases, no bill, because I put together a pretty good grand jury packet. And if anybody don't know, just very briefly, grand jury, all felony cases have to go through grand jury. Okay. And the grand jury decides if there's enough evidence to move forward, which they call a true bill, which they also call the indictment, or they also can make a decision to no bill the case, meaning there's not enough evidence to go forward, and they can dismiss the case right then and there. I mean, we had capital murder cases, no bill, because we put together solid grand jury packets for the grand jury to consider and say, hey, this is not even enough evidence to charge this person. I could think of at least 2, for sure, murder cases, capital murder cases, that were no bill because of our efforts in the very beginning. Another reason you want to get us in the very beginning is because we want to be the ones that conduct those preliminary hearings, those bond hearings, those pretrial hearings. We want to lock in statements of the officers. We want to lock in statements of the witnesses, because once we got those locked in and we grab those transcripts for their reporter, they can't go back on their word no more. So their story has to be consistent, whether this is 2020 or we talking about it again in 2024, because I got what you said in 2020, right? And if you say anything different, Mr. Officer, you lose your whole credibility. So, we have our reasons and strategies why you want to get us in the game early. Check us in early, coach. We some starters. We don't come off the bench. We some starters.
Yeah, I mean, and to be honest, people don't understand the tact in what we do. My esteemed colleague here said that, you get them locked into statements. But you got to understand, we want to be the ones to apply that initial pressure. You see what I'm saying? That bond hearing, when they hear the way that we approach our questionings, when they hear the way that we attack them witnesses, when they hear the way that we kind of stand on what the law says and what the facts are, they know we not playing. You see what I'm saying? So those are important proceedings. And what he means by getting somebody locked into their statement, if we subpoena the detective to the bond hearing, he got to stick to what he said in the bond hearing and trial. He can't say something different in trial than he said in the bond hearing. I got him. I'm going to get him anyway. But I could get him like that quicker. You see what I'm saying? So, bringing out the fact that there's different witnesses, bringing out the fact that there's a potential self-defense claim, bringing out the fact that there's other affirmative defenses. Doing that not only puts the state on their heels, but it also will compel that judge to lower that bond. You see what I'm saying? So, you definitely want to get us in the game as early as possible. Like, we don't do appeals. I ain't no sniper that's in the back. I'm a frontline soldier. You understand what I'm saying? I'm running with the musket.
Come
You know what I'm
on.
saying? On the front line. You know what I'm saying? So we don't like to clean up what another attorney has done, because we kind of operate. It's a lot of good attorneys out there, man, but I think we apply a certain amount of pressure initially that most attorneys think they don't need to apply. We negotiate a little bit different. I mean, we straight to the point, man, and we standing on it. And we review the evidence relatively quickly, and we do it multiple times. And like I tell my clients, every time I look at the evidence is for a different reason. I'm looking for something different. You see what I'm saying? So, like I say, just find somebody that you're comfortable with. Don't go get the guy that's telling you $500 down and then be mad, you know what I'm saying, when he don't put in no work. Well, damn, you gave him $500. You gave him 3 tickets to Six Flags. You see what I'm saying? So, you probably want to get somebody that you're comfortable with, somebody that is confident in their work, man, and somebody that's going to go ahead and make the moves that need to be made on the front end. We are proactive attorneys. We're not reactive attorneys. We're proactive. And there's many of them out there, and there's many of them that just say they are, But, whatever it is you're comfortable with, whatever style it is you're comfortable with, go for that. Go for that.
Absolutely. And what I want to piggyback on what he said is that, you take $500 or even $5,000 to an attorney on a murder case, to get him started. Don't be expecting much work from that attorney for that $5,000. He may come off like he gonna do this, that, and the other for $5,000, but soon as that case ramp up, he gonna need some more money. He gonna want some more money, or he getting off. And I tell people this all the time. Like, when you hire an attorney on an M, that's the highest charge in the land. You can't get no higher than murder. Capital murder comes with the death penalty. It can't get no worse penalty than losing your life for a case. Okay. Oh, what is your life value? Okay. What is the value of your life? When you want a great attorney, you have to pay for great attorneys. Great attorneys cost money. And I'm not talking about, your normal living. You may have a couple of extra $1,000 after you pay all your bills a month saved up. That ain't gonna get it done. That's not gonna get it done when it comes to hiring a great attorney on a murder or capital murder case. People, they have to do things that they feel uncomfortable all the time when it comes to paying for a great attorney. Some people got to put up their house.
Right.
Some people sell their car. Some people got to dip into their 401k.
Right.
Those are things that you may have to do to save your life when it comes to fighting a M or a capital M. You got to, your paycheck to paycheck, that ain't going to get it done. That ain't going to get it done. So when you hear the case, when okay, I'm charged with a murder case, okay, I need to look at my finances to see what type of attorney I really can afford. Okay. And another thing when it comes to attorney fees versus, okay, I got $30,000, but my bond is $250,000. Do I hire my attorney or do I bond out? I'm gonna tell you a story about a lady who had a son. Their son wanted to hire us. We did our consultation. We quoted her our fee. I think back then we only wanted like $15,000 down. That was good. Okay. And she probably had about 10 or 15. But her son convinced her not to hire us and to spend that money on a bond company and bonding him out. That's never a good idea. People ask us all the time, should I bond him out or should I hire an attorney? It's a no-brainer. The bond company is only there to do one job, to make sure you go to court. That's it. Well, 2 jobs. They get you out of jail and they make sure you go to court. The attorneys are there to fight for your life and your livelihood and your freedom. So which one is more valuable to you? And then so this lady was convinced to get her son out. And I see it all the time. This didn't happen in this situation, but those sons will violate them bonds real easy, especially in Tarrant County. Don't smoke a blunt when you get out because you going back in and they doubling your bond. Don't have hey, don't have a drink when you get out because they doubling your bond and you going now your $250,000 bond. It's a $500,000 bond for one blunt. That's an expensive blunt, but they don't play like that. Yeah, and that's a story for another podcast show. But the county know what they doing. They want you to mess up. They're gonna put you right back in there. Well, her son didn't mess up, but unfortunately he passed. So that money she spent on a bond, she never got the value out of it because they weren't able to do their job. God rest his soul. I pray that she's at peace, but has she hired us? Who knows?
Yeah, man. That was a tough situation. So let's shed some light, man, on the trial we just had. The way it started off, one of the strategies we had, it was a video, right? So the detective, he chose to try to calculate my client's speed. So you got to understand, in intoxication manslaughter, most people think that if you're intoxicated and a person dies, then you're guilty. That ain't how it go. It says that if you are intoxicated and by reason of the intoxication, the fatality occurs, then you're guilty, right? So they have to have a causal connection between the intoxication and the fatality. It ain't just that you was intoxicated and somebody passed. It has to be a causal connection. So what they were trying to do is say, and we knew from the jump, they were trying to say that my client was so intoxicated that she was speeding at a high rate of speed. Most of the time, speeding is not an indication of intoxication, okay? But in some cases it is, all right? Most of the time it's swerving or driving erratically or not driving fast enough or something like that. But in this situation, in a few other situations, they were trying to use that as an indication of intoxication. And we knew that. But nobody knew what speed she was going. So the detective took the video, and he tried to calculate the speed by using the video. Well, what we knew was, because the detective had divulged the information to the prosecution, that he was not an expert in video forensics. And he needed the frame rate of the video to calculate the speed. So what we did is when he got on the stand, I made him testify that he was not an expert in video forensics. He was under oath and he testified to that. This was in a 702 expert hearing outside the presence of the jury before the trial. Well, when trial gets there, and so what we did was we argued to keep the speed calculations out on the basis of him not really knowing what the frame rate was. What that means is if he plugged in the wrong frame rate to the formula to calculate the speed, then the whole equation would be effed up, right? I mean, that's just simple math. 2 plus 2 is 4. 3 plus 2 isn't, right? So, you got to have the right, you got to have the right variables in the right spots. And what we did tactically and strategically is we argued to keep it out, but until we felt like it should come in. And I don't know if you picked up on that, Mike. I don't know if you picked up on that. Whenever I brought it in and they were like, hold on. The defense argued for it not to come in. And now he's opened the door. And now we get to talk about all the speeds. And what I say right there in front of the judge, I don't care about that. Talk about him how you want. Because now I done told the jury that he ain't even qualified to do the damn equations. Right. You see what I'm saying? So that was like, that's a strategy that we apply in most trials. Like, first and foremost, these DAs gonna get enough of underestimating us, man. And maybe we'll do a show on the art of underestimation. I ain't gonna go into it right now, but let me tell you something, people. Y'all like to be sad. Y'all like to be mad. Y'all like to really give it a gander and wonder why these people are underestimating you. Let them, and kick their ass all over the courtroom every time they do it until they learn not to do it. But we'll talk about that another time. But what we did was I kept that out, and as soon as we felt like, and what I did the whole time was, I kind of forgot what I told the detective. I think we opened up. I said, while the detective was on direct, I was doing different things like acting like I wasn't paying attention. You know what I'm saying? But like not obnoxious, not being obnoxious, but making it pretty obvious, you know what I'm saying? But I wasn't being rude about it or nothing. I even got up and act like I got on my phone and walked out the courtroom while he was testifying, right? And then when I got on cross, I said, sir, how many of these cases have you testified in? When somebody has died. I said, pretty serious case, right? He said, yeah. I said, well, has the person that's supposed to cross-examine you ever walked out while you were giving your direct examination? You remember, Mike?
Right,
And I
right.
was like, you have no clue I was that comfortable doing that, do you? And he said, no, I don't have a clue. I said, well, could it be? Because you've already testified under oath that you're not even qualified to testify to what you testified to. Could it be that you testified with your right hand up under oath, might as well put your hand on the Bible and said that you are not an expert in video forensics? You see what I'm saying? And at that point, the jury's mouth was wide open, kind of looking at him like, damn, you done gave us a whole presentation over this shit without telling us that you ain't qualified to do it. So at that point, I started talking about the frame rates that I didn't want to come in. And that's when the prosecution was like, well, now we can talk about frame rates. I said, bet, talk about them. If y'all want to stand up and lie about, you know what I'm saying, after I done told the jurors that this man ain't qualified to talk about them, that's like a damn biologist talking to you about physics. You see what I'm saying? He don't have the acumen to do it. You see what I'm saying? And I don't know if you remember, Mike, but they never brought them frame rates up.
Right.
Even after saying they was going to do it, they never brought it up because they were scared to then. Like, why are we going to bring it up now? Mr. Wilkerson had tainted the jury and told them that if we bring it up, then we ain't qualified to bring it up. So they never brought it up. But it was different strategies like that we did. And we basically painted a picture for the jury to basically what our strategy was even if the jury finds her guilty, we will present this case in a way where the jury will understand it and sympathize with our client just enough to give her a second chance. And that's what they did. Our client had a green light. She wasn't doing nothing but legally going through the green light. This woman was jaywalking. Okay. That's a violation of the Texas Transportation Code. So she was actually breaking the law. You see what I'm saying? We brought up the part to where I had the detective testify that, you know, if she filed an insurance claim, it might not get paid because she contributed to her own demise. And you got to understand, it's an art to be able to do that without being an asshole about it. You see what I'm saying? It's an art to be able to tell the jury that this woman contributed to her own death without them feeling like, well, damn, that's kind of harsh, Mr. Wilkerson. You see what I'm saying? You got to walk that line. You got to know how to walk on that tightrope. You know what I'm saying? To where they know you sympathize with this person, but same time, they should sympathize with your client as well. What you think, Mike?
Yeah, absolutely. A couple of things you touched on the frame rate. What we did, which was brilliant, we would have got our own expert because all they had to do, and this is just lazy prosecuting, all they had to do
and detective work.
Go get a video forensic expert who can look at who can then try to ascertain what the frame rate was. They didn't do that. We would have got our own 40-year video forensic expert, and he testified that there's no way they would have known what the frame rate was of this video because they didn't ask. They didn't even know what type of device was recording, the type brand of the device that recorded. And if you don't know that, then you don't have that first variable that goes into that formula, and your formula is wrong. So we was able to brilliantly argue that. We argued that because you mentioned jaywalking. We argued that through the law of a defense of concurrent causation, which we successfully argued that before in the past. Concurrent causation means that if another cause in and of itself could have caused this accident, and my client's actions of just driving through the green light were insufficient to cause this accident, then she can't be found. She can't be found. Yeah. Can't be found guilty. That's the defense that we put out right there in our bag. Because when we need to pull that boy out, we ready to go. And this was a concurrent cause case. But for the lady jaywalking, this accident would have never happened. You know? So, and we got some people to agree to that on the stand too, some of the state witnesses, that if she wasn't illegally in the intersection, this accident wouldn't have happened. And, you know, there was three things that I knew that were going to be problematic for us. They were going to try to harp on the speed, but they didn't really know the speed. They were going to try to harp on my client's blood alcohol level, but it didn't matter because it, like Drew said, intoxication wasn't enough. Intoxication had to be the cause. When you think of that, that's normally somebody driving up on the curve and running somebody, or, you know, falling asleep at the wheel because you're so drunk, running to the back of someone, or, you know, Ethan Couch. Y'all know that name, Ethan Couch, 10-year-old out of Tarrant County, who argued affluenza and why he should be given probation. and the judge went for it, but he killed 4 people. 4 people. You know what I'm saying? So that's what most people think of when they think of intoxication manslaughter. But here we argued that my client's intoxication really wasn't the cause of this wreck. It was some other reasons that caused this wreck. And I think the jury, they bought it. And I think that was mitigating in the outcome of this case. Now, the inevitable is they found our client guilty. However, that is not the end for the not guilty boys. The not guilty boys stand to the second part of trial, which is punishment.
For sure.
And in the punishment phase, our client is probation eligible. We're doing everything we can to give her probation. You know what I'm saying? And she was looking at 2 to 20. If convicted of this and they sentenced her to prison time, they could have sentenced her up to 20 years. But she was also eligible for probation. And when we select the jury, I asked them, I always ask this, when there's a case, when there's a dead body involved, can you consider probation? Can you really consider probation after hearing all the factors, after hearing all the testimony and seeing all the evidence? Can you withhold your judgment and at the end strongly consider probation for my client if the factors suggest that? So just because they came back guilty, that's not a defeat. This came out and they gave my client, because we put her on the stand and she was able to tell her story in the punishment phase. See, we didn't put her on the stand in the guilty and innocent phase because for several different reasons. Some people are just not good, test takers. Some people get nervous under pressure. And we didn't want that to play a role in them thinking that she may be lying or being deceitful to them. So, you can't hold it against my client if she chooses not to talk in the innocent and guilty and innocent phase. But she did decide to talk in the punishment phase. And that was when they were able to see her persona. She was remorseful for this. This has plagued her for the last 5 years. This has weighed on her heavily for the last 5 years. We had an expert to say this was a tragic accident, and it was a tragedy to both the deceased and also to my client. Okay? Because my client didn't go looking for this that day. She did not. It was not her intent. She wasn't malicious. She didn't even know she hit the lady. And like I said, that can happen to anybody. But what type of person is she? She got up there and talked about how she gives back to the homeless community, that she believes in teaching her kids to do the right thing. She's never been convicted of a felony before. So if she keeps the job, she is a good person.
Hold on, let me give my boys flowers though. When I walked back in the courtroom, he asked her, "Do you think you deserve to go to jail for this?" She said, "Yeah." I'm talking about some compelling shit, man. And I'm looking at the jury. She said, "Yeah." I leaned in over the bro. I said, "Bro, you thought about it? That was your idea?" He said, "Yeah." I said, "Bro, that's moving, fam. That moved me." And I'm the attorney. You see what I'm saying? So, I just wanted to give you flowers on that, bro. That was really work.
Right before we started and I put her on the stand, I told her, I'm going to ask you the hard questions now. But no, it's a method to my madness. I wanted to ask her all the hard questions because I didn't want them to be able to attack her. So you would think I'll sit at the state table. Now, look, it's a dead body here. You think you deserve probation? Well, I may deserve to go to prison, but I don't think I should go to prison and her answers was just perfect. It was just perfect. But I wanted to ask all the hard questions because I wanted to reduce the stain for when the state got to cross-examine her. And it worked out. And, I think one of the major reasons we won this case is because of, number one, we are believers. Okay. We're believers in Christ, strong believers. I read my Bible and pray every morning. You know what I'm saying? And I know Drew does too. Drew actually has most people don't still have a physical Bible. I see Drew with his physical Bible with the highlighting like it's 97, getting in his bag. You know what I'm saying? And, this case is all about forgiveness, and a second chance. And we felt like our client deserved a second chance. So, typically, we play off each other. We work well together as a team. Sometimes I give open statement, but normally in punishment, I'll close. But this time, I don't know why, right before it was time for us to go up, I say, Drew, you might want to do like 3 minutes of a closing. See, I know the thing about Drew, he speaks so elegant. He's an English minor. So he's great with his words. He's great with his speech. Mock trial really preparing my boy for this. So, I say,
Appreciate that.
give him 3 minutes. Just give him 3 minutes. Now, Drew is a closing genius. He closed every case and he takes pride in his closing arguments because that's what put the bow and ribbon on the president, just gifted to him like that. Make it so sweet for him. They ain't got no choice but to say not guilty. But we went to the punishment phase and we was getting ready to close. And I said, Drew, I think you should close for about 2 or 3 minutes. He said, for real, you sure? I said, yeah, just give him 3 minutes and I'll come out to you because I had mine prepared. Well, I've heard my boy close at least 25 times. And these 3 minutes may have been the best close that I heard him do. And the reason I say that is because, first of all, he took her to church, started out in Matthew and had the story of Paul and how Paul,
Peter.
excuse me, story of Peter, and how Peter was forgiven 777 times by Christ. Now, we was asking just for a second, a third chance for our client, but if Christ can forgive one 770 times, who are us not to be able to forgive someone multiple times? That was brilliant for this situation. Just
Appreciate
brilliant.
it.
And I think it resonated with the jury because we always talk to them once the case is over. And when they came back that they was giving our client probation and we talked to them, they said they didn't want to overpunish her. They felt that she deserved some forgiveness. So I think that was one of your strongest closing argument in 3 minutes you got. And let me say this before I pass it on. A lot of attorneys can't get in that bag. They can't get the biblical scripture bag. A lot of attorneys can't get in that bag. You know what I'm saying? So that's just extra bag, bro, carry it when it's time to go to work, man. So, hey, man, kudos to Drew for closing the case. Man.
Appreciate it, brother. Yeah, I opened up. I took them to the tabernacle. I
Come
opened
on.
up with Matthew 18:21 and 22, and basically Peter. Old Pete was a gangster, but Pete got a slick mouth. So he was talking to Jesus and basically said, well, how many times am I supposed to forgive somebody? 7 times, my brother or sister, when they sin against me, God. 7 times, 77 times. How many? He really being funny with Jesus, but you know how Jesus always let it roll off his back like water off, on a duck back, man. He said, nah, you 777 times. Forgive him 777 times. Peter was like, but basically what Jesus meant was you ain't supposed to be counting, brother. Like it ain't a number to it. Like the trick is to do it. It ain't no, you ain't supposed to be taking score. Now, of course, Jesus didn't mean that you need to stick around for somebody to spite you 777 times either. But, the point is that, because we knew the prosecutors were going to get up here and say exactly what they said. What she say? Forgiveness is about me. Justice is about us. Is that what she said? Some shit like that. It was something.
He said that.
It was
I'm
something.
like, whoa, that's cute.
Yeah, come on now. Where you pull that out from?
It didn't
But
stick.
yeah, it ain't stick. It slid right off the wall. But
Yeah.
I thought that was appropriate, man. And that was off the cusp,
Can't
So,
nothing convict you like the word of Christ, man.
Right.
If there's anything that's gonna hold you to doing the right thing, it's gonna be that word. And I know it resonated with this jury because one thing we always do when we pick a jury, we look at every element of that person. And most of these jurors were Christian,
Catholic.
Yep. Oh, they believed in a higher being, so they know what forgiveness is about. So it was just the perfect closing for the situation. I thought.
Yes.
So our client right now, statutorily, she does have to do 120 days, but she did get 7 years probation. Hey, she'll be out in July, and she'll be back to living the rest of her life as a law-abiding citizen.
Which she genuinely deserves, man. She is a good individual. She's a good human. You know what I'm saying? And I mean that. It really, it was crazy. Like the jury only deliberated for 2 hours on her guilt to come back with a guilty. And I think that it was really just one, no matter what they told us in voir dire, I think that there are just certain cases that have a certain stigma to them, particularly death cases, particularly sexual assault cases. Those kind of cases, people almost deem you guilty before they even hear the story. I mean, it's just a humanistic part of people, you know what I'm saying? That precludes them to be able to, sit and listen before judging you, you know. So I think the jury I don't think we've ever had a jury come back that quick with no notes either. Usually a jury will write some notes and have some questions for you during the guilt and innocence deliberation, but they came back before it was time to leave, man, with a guilty. And then they deliberated for 2 whole days. And you could really say 4 because they had the whole weekend to think about it too. So they had Saturday, Sunday, all day Monday, all day Tuesday. And they came back with that probation, man. And that's just by the grace of God. Glory to God. It's nothing but a testament that he does believe in second chances.
Absolutely.
All our strength, all our acumen, all our intellect comes from Jesus Christ, man. And I just want to put that on the front end. I am a Christian. We are Christian, and we don't mind people knowing that. So if you hire us, that's who we leaning on. That's who we depending on, you know?
Right. And we're not sugarcoating that in court either. I mean, I think more than anything else, everybody in the courtroom needs to know we Christian, you know, because like the words say, if we can do anything to make someone want to get closer to Christ, then we doing our job. You know, we're doing our job. So, 7 years probation and 8 years. 8 years probation. She's doing 120 days. She's gonna be out. She's gonna be fine. She stopped drinking after this happened. She hadn't had a drink. She hadn't done anything wrong since this happened. And I think this was a great outcome. This is justice prevailing the way it should, in this situation.
And we still 14-0 in murder cases, man. I know y'all waiting on a blemish. Y'all waiting on a nigga to trip over his shoelace, you feel me, and land on his face. But not yet, baby. It was a death case, but it wasn't a murder case.
It was manslaughter. Get it right.
It was intox manslaughter. You understand what I'm saying? And on our very first one, and understand, nobody from our mamas to the preacher to any other attorney thought she was gonna get probation. Nobody.
Not even the judge.
Not even the judge. As a matter of fact, we were going to go trial by judge at first because in DWI cases, there's a certain science involved. You got retrograde exfoliation. You got, the blood alcohol level. You got all this science involved. And most of the time, the DAs will kind of trick the jury. They'll trick them on what the law is, or they'll trick them on how to apply it. And we didn't want the jury to be tricked. So we were scheduled to go trial by judge. Well, it turned out to be a blessing in disguise. I really ain't like it initially, but it turned out to be a blessing in disguise. The judge was like, I don't know how I feel about this case. Although she qualifies for probation, I don't know if I'm going to give it to her. Just a lot of undertones to where it was like, no, we going to go to the jury. You know what I'm saying?
Right.
Last second we called an audible like Peyton Manning. You understand me? And went ahead and went to the jury. I had a jury trial. And what's wild is wild. It's wild because you had jurors in the beginning that were saying, I can't be fair to your client knowing somebody died. These people don't even know the facts. You see what I'm saying? Knowing somebody died. Well, after I asked the judge, I ain't going to say what judge it is because I like Judge. You know what I'm saying? I like Judge as a person. You know what I'm saying? So, but basically what she said was, I loved your client. Because I asked her after, I said, Judge, would you really have sent her? Because, I be trying to check my work. You know how the math teacher used to make you check your work. So after, I do that a lot. I talk to the jury, I talk to the judge. I say, Judge, would you really have sent her to prison? She said, oh, yeah, I probably would have sent her to prison. I said, would you have gave her 10? Because the state was asking for 10. Now, the maximum was 20, but the state was asking for 10. No, I wouldn't have gave her 10. I said, would you have given her 5? No, I wouldn't have given her 5. I really liked her. What about 2? I don't know about 2, maybe 3. So judge really overplayed, and that just shows you if this is a person with legal acumen, somebody that's been to law school, somebody that has tried cases, somebody that is now sitting on the bench, right? As a judge, couldn't really fight her emotional investment enough to sit back and listen to the case before making a judgment. It shows how it plays on the jury. You see what I'm saying? That's a real thing, the emotional aspect. And that's something Mike is very good at doing in voir dire and opening. And Mike ain't tell y'all he withheld his opening in this case too, which was genius too. But we'll bring that back though. But Mike is really good at letting people know, keep your emotions over here. Keep your logic over here. The state wants you to tap into them emotions because you'll click that guilty box quick. Mm-hmm. You'll click it quick. You see what I'm saying? But if
Right.
you listen logically and use your logics, it's almost like what they say, man versus women, like women way more emotional, men trying to get to the bottom of it. I ain't gonna get too deeply into that because I don't need y'all hating on the nigga. You know what I'm saying? I ain't trying to start no gender war. But what I'm
Right.
saying is that you have to be able to tap into both of those sides in order to properly apply the law. You see what I'm
Yeah.
saying? If you just mad somebody dead, you don't really care what the law say. You think that person guilty. But if you use your logics too, it allows you to apply the black letter of the law and still sympathize with the victim enough to make sure that they get justice, which actually happened in this case. They found Swanetta guilty, and they found a way not to overcharge her or not to over punish her, and gave her probation because of how we presented the case to them. So well
And we
done, Mike.
glad
Well done.
we all celebrated that as a win. Free legal attorney in the community who knew about this case called it a win. Our client thought it was a win. Our client's family definitely thought it was a win. It's definitely a win. You know, they're not guilty boys, like I say, that extend to punishment too. Because if they do come back with guilty, we still know how to get you on. We still know how.
We don't go to punishment often. You feel me? We don't go often. Most time it's a 2-word verdict, and we to the house with our babies. You know what I'm saying? So understand that's something that your lawyer, a good lawyer, knows to be prepared for too.
And your lawyer might not have ran it audible. If he wasn't on the case early enough, if he wasn't prepared, he may would have stuck to judge. And guess what judge would have did? Judge would have sent your client. Even though it would have been 3 years, she still would have sent your client. So, we're not bragging. We just educate you guys on how these things go at, what we do and our strategies and our tools that we use to get justice to play out the right way. We just let y'all know, if y'all need us, we on Facebook, we on Instagram. Again, thank y'all for liking, watching, and subscribing to these podcasts. Again, this is just raw information. We go keep working to get better at this. But Drew, what's our 844 number if they ever need us?
844.
That's how you get in contact with Wilkerson and Campbell if you need some great attorneys, and we'll be more than willing to help and more than happy to help.
Yeah, man, it's just another episode. Docket dialogue is what we call it when we kind of share some insight about our cases. Go ahead and subscribe to my Instagram page if you want some behind the scenes stuff on how we prepare, how we perform in trial. We got another murder trial coming up in the 3rd District Court on the 7th floor of the
That's
Frank
not
Crowley
guilty.
building.
That's
What is that? April
April.
28th. That is an ironclad murder trial. It's not an intoxication manslaughter. Come pull up and see what's really going on.
I
I
think
don't know
this.
if it.
Go ahead, my
Go
bad.
ahead. I don't know
No,
if
I
you
was just
really
gonna
know many attorneys that's confident enough to tell you, hey, don't worry about the work that I've been done that I could tell you about. Come on, pull up to something that where I can't tell you what the outcome's gonna be. I can tell you what I think it's gonna be, but come see the skill set, man. Yeah, come check in and tap in.
And we actually had a client to take us up on that offer at this last trial, and he was
We did.
impressed.
He
knows
just hired us on the murder. We turned around and he was in the courtroom like, yeah, I'm here to see what y'all got. And he seen what we got, man. So, he knows what he's paying for. He knows the product he gonna get. And to be quite honest, he got a lot more mitigating issues going on than our other client did. I almost said her name, our other client. So looking forward to that one. That was gonna be in Tarrant County in what, July or June?
In July.
So yeah, we'll keep y'all updated on what we got going on. All these ain't gonna be docket dialogue episodes, but we just felt it was necessary. This being a 9-day trial, man, the longest trial we've ever been in at this point. So I appreciate y'all. Yep.
Follow us on Instagram, the Not Guilty Boys, at attorney Andrew Wilkerson, and attorney _ Mike Esquire 25. On Facebook, we on TikTok, we on YouTube. We're not hard to find. We checking out Not Guilty Boys.